Greetings. I am Julie Mintrumberg, and today I am going to talk to you about a current issue in the United States concerning freedom of expression. Over the summer, despite protests from local farm workers, North Carolina passed the North Carolina Farm Act of 2017, also known as Senate Bill 617. For more information about those protests, you can see this newspaper article by Dante Serbino in Workers' World. If you pause the video, you can get a look at that website. The bill included two amendments that the farm workers opposed, and now the Farm Labor Organizing Committee, also known as FLOC, is suing North Carolina over it. For more information about that case, you can see Melissa Boughton's article in the Progressive Pulse, and again, you can pause the video for that website. The First Amendment prohibits agricultural producers from signing. The First Amendment, not the First Amendment to the Constitution, but the First Amendment to the Farm Bill, prohibits agricultural producers from signing any agreement with a union relating to a lawsuit, including an actual settlement. This significantly reduces the collective bargaining power of unions. For example, FLOC has used such agreements to secure improvements in working conditions for farm workers and higher wages. The primary sponsor of the bill, Senator Brent Jackson, owner of Jackson Farming Company, was recently sued for wage theft by Latino farm workers alongside FLOC. You can see this article again for more about that. The Second Amendment to the Farm Bill, and the one I will be focusing on, prohibits farm workers from having union dues transferred directly from their paychecks, even if the worker chooses to do it, and even if the employer agrees to it. The problem with this law is it discriminates against migrant farm workers, who are unlikely to have U.S. bank accounts, credit cards, or other means of making payments. This would mean that FLOC would have to drive all over the state to collect its dues manually from over 700 farms. For more information about that, you can see this article by Nolan Rosenkranz in the Toledo Blade. There's the website for you. As Claremont Ripley, a staff attorney with the North Carolina Justice Center Workers' Rights Project, pointed out, farm workers are among the lowest paid and most vulnerable workers in the state. They arguably need a union more than anybody else does. The Farm Bill has serious implications for freedom of association. As the Supreme Court stated in NAACP v. Claiborne, the practice of persons sharing common views banding together to achieve a common end is deeply embedded in the American political process. By collective effort, individuals can make their views known when, individually, their voices would be faint or lost. Since North Carolina is a right-to-work state, the employees would have to agree to have the dues deducted from their paycheck anyway. This is in line with analogous Supreme Court precedent concerning public employees. In Abood and the following cases, the Supreme Court found that compelling someone to participate in an ideological cause is unconstitutional. Here, we have the exact opposite problem. The farm workers had to opt in to automatic deductions. No one was being compelled to support something, as in Knox. In contrast, the government is limiting the workers' right to support something by banning an established means of paying for it. The Farm Bill also implicates FLOC's freedom to define itself and its goals. In NAACP v. Claiborne, the Supreme Court noted that the NAACP did not have unlawful aims, or endorse violent means, thus could not be found liable for the actions of a few of its members. Likewise, in Boy Scouts of America v. Dale, the Supreme Court simply accepted the fact that Boy Scouts wanted to discriminate against homosexuals as part of its self-identified mission. Part of FLOC's self-identified mission is to be readily available to support diverse, low-income, migrant, and stationary workers. The government is therefore unfairly and unreasonably limiting FLOC and North Carolinian farm workers' freedom to associate.